Notoriety, attention, and fame are all closely related terms. They play in the same ballpark, but they don't play by the same rules. And so it is with public relations and marketing. Seemingly interchangeable terms aimed to garner attention. One seen as reputable, the other seen as desperate. One seen as a waste of money, and the other as a worthy investment. One seen the way you see it, and the other how they see it. Wrongly. What if the goal behind PR and marketing, these ways to get attention, notoriety, and recognition, isn't just claiming the spotlight, but something that provides a stronger benefit to your practice, that extends past your services and begins to create and shape the narrative of your law firm's destiny? That's what we're talking about today on Lawsome. Public relations, marketing, and the way lawyers can succeed in the court of public opinion. Ready? Let's do this.
Lawsome, the podcast for law firms. Powered by ConsultWebs.
Welcome back to Lawsome, the only podcast for law firms that firms up when left in the fridge and can be eaten as a dessert alternative. Ooh. We're here to inform, educate, and entertain the legal community on the latest in legal marketing and law firm development. I am human sauerkraut, Jake Sanders, and with me is the sausage king of Chicago, Paul Julius. Paul, what's sliding into our show buns today?
So, I know you threw that right over the plate for me there, and there's a lot of different directions I can go with that, but I just wanted to share an experience I had recently with all our listeners. And there's a type, I don't know if everybody has this everywhere, but we can get an Italian sausage combined with an Italian beef. It's called a combo sandwich here.
What? Huh?
Yeah, and I had one last week. It'd been the first time in a long time. I don't know how people survive those things, to be honest.
Did you wake up underneath like a bridge or something?
I blacked out.
Meat blackout. Portion control. Let's tell people what is on the menu today for them on the show.
Oh, yeah. So here's what we're cooking up. We're going to talk public relations and law firms with an article from Above the Law. Then we discuss how lawyers can effectively and ethically manage media relations, PR, and marketing for their firms in an interview with the founder of CopoStrategies and PR mastermind, Wayne Pollock. And then we throw our guest into the court of 5 questions we ask everyone.
Pull up a plate. It's the Hot Takes Buffet.
The article today on the Hot Take Buffet is from the Above the Law blog. It's a sub-blog called The Practice for Solos and Smalls. It's by lawyer columnist Brian Tannenbaum. And it's entitled, Are Public Relations Firms Still Relevant? And that's a question. And he starts by saying, yes. Now go back to whatever you were doing.
I like that.
Oh, man. He
takes guts.
But his just to frame the Tannenbaum flavor, at the bottom his byline, it says, Brian Tannenbaum will never, quote unquote, get on board at the advice of failed lawyers who were never a part of the past but claim to know the future of law. He represents clients every day in criminal and lawyer discipline cases without the assistance of an Apple device and usually gets to work in an office, not a coffee shop, by 9 a.m. No client has ever asked if he's on Twitter.
You know, Brian, I thought we had done an article of Brian's before, but I would have remembered that byline for sure.
We're new. Yeah, we're new to it. So, but he was a solo and then he started his own firm. And the first thing he did was hire a public relations firm to help with publicity. And he said he couldn't afford it, but he thought it was important and that it would somehow pay for itself. And it does by the end. My hot take is on this article is that there is a distinct difference in between PR and marketing. And Brian explains that, Wayne explains that in really crystal clear language, because a lot of lawyers are worried about the grifty nature, sales pitchy nature of firms, marketing, PR that could help them, but they're not quite sure how to weigh the benefits. And it all starts sounding the same because you don't know the distinct benefits that it can bring to your firm. Talking to Brian, about this article, he lays it out, says it's expensive. You have to interview them. They have distinct resources at their disposal too, in different areas. If you want more social, if you want more mass media, if you were a trial lawyer, if you were working on this side or that side of the law, he discovered that PR firms work different angles, just like law firms. So they have sub-practice areas. A lot of amazing insights here. And hands down, I mean, above the law, helping solos and smalls get that good advice. I think this is a good example. And Brian's so sassy.
Well, but you know what? This is not a sassy article, though. I think this is extremely valuable, and it really ties into why we were so amped to have Wayne on here and talk about it, because you and I think get it very, very well, the difference between PR and marketing, and particularly digital marketing, and even marketing and advertising. These are all kind of things that it may all just mush together into one big bowl of applesauce for people who don't get in there every day. But one thing he says here is that what a good PR agent does well is to put you together with the right people and events and keep you away from the wrong ones. And so these are things that, as people who have been on the digital side as well, we always talk about, Jake and I, we've talked about this particularly with regards to local before, and reviews. You need to amplify the good stuff and spread it around. People are going to be looking to verify those sources today more than ever. And that is not something that every digital marketing agency is going to be able to handle. I mean, that's just bottom line. Getting you into those newspaper articles, getting you to be the first law firm that a TV studio calls when they need an opinion on a personal injury matter. That's what PR is all about, man.
And it's about relationships.
Yes, absolutely.
And creating those offline structures that then can support whatever digital marketing efforts you have.
Yes.
That's why a lot of people think that it's a replacement, and we are consistently confronted with the reality that you need multiple levels, multiple different approaches to solve these problems. It's not just going to be, I just did some press releases and I threw them out the window, and
and whatever. That's it. That's as far
and
as
I was on the front page the next day.
It went to these PR blogs, and that's the end of it. Like I know I keep bringing up, the Chicago firm that I am, their client and consultant. I'm very impressed about it.
Yeah, Salvi's big.
I'm not going to say any names, but their initials are Salvi Law Firm.
Okay.
And they, every time, because I live in the same area, I see them. They are that firm. When a news, one of the channel, the big three, ABC, CBS, NBC, whenever they need somebody for a law, a personal injury matter lawyer thing, that's the experts. When all the big cases, and these guys, they don't do TV advertising, but the way they are on TV is their advertising for them. They get the biggest cases, and they look sharp every time. They make the most out of those appearances. And the thing is, they're the exception. They're doing it so right. It's so easy to see the stark contrast, and we bring it up later on with Wayne, but it's, it's something that, like, once you get that thing in motion, it's just a machine, man. I mean, it's unbelievable.
Yeah, but it's a machine. And so, but it's like, but not everybody is going to have a Cadillac. So when you say, like, this is the way to go, well, then imagine if everyone had Cadillacs, it wouldn't make it special. There seems that there's this dominant, well, but there's like this. So if everybody's supposed to, dominate, and I'm just kind of coming from the side because people are saying, well, then PR isn't for me, and a strategy isn't for me, and the way people perceive me online or reputation management wise, whatevs, because it's about my service. And as David Kempston said, it's not about your service.
One of the things I noticed right away was that my clients didn't always recognize good lawyering. In fact, they often did not. They would confuse bull in a china shop behavior with good lawyering, and they would log that. And conversely, when I would do something, that was subtle and clever and, worthy of praise, a client might not see that at all. And I learned that clients, they don't always recognize good lawyering. In fact, they typically don't, but they do recognize and almost always respond to good customer service. And I began to realize that from a client's perspective, they may not know whether you know the law or not, but they do know if you provide good customer service.
Because your clients don't understand what good lawyering is. So then hoping that you'll get network effects from somebody who doesn't understand the quality of the work you do, you're just fishing off a pier with nothing on your hook.
Oh, well, true. And I mean, I'm not saying that every single person should have a 5-person,
Right.
team that is going to set up a press conference outside a courtroom. It's not always going to be like that, but there is definitely lessons to be learned, I think.
But someone would say, well, how could I incrementally get towards that? And that's where thinking of PR as a relationship builder and then maximizing that with digital marketing, complementary. These are the realities that we weave into and out of, talking about the benefits, the side benefits of PR that come not just from generating prospective clients, but generating goodwill amongst your existing clients and helping you solve cases in a more diverse way. You can find new discovery routes for information, for your case to strengthen it and build it.
Absolutely.
It's unreal. So we get into it, and we should, but I want to end it with Brian's sass. And he kind of couches digital marketing as one thing. And I think when you hear what Wayne lays down, you'll see that Brian has the relationship angle here right. But there's a predatory angle that isn't here for people who, like ConsultWebs, like CopoStrategies, digital marketing firms that understand PR. You have someone in your corner. But this is what he ends like this, and we'll end it, and we'll go into the interview, and you guys make the call. While every lawyer in town is running to the so-called digital marketing firms, consider a public relations firm. You may find it better to actually meet the people that can help you build your business, rather than hope they are pointing and clicking their way to your bank account.
Lawson continues. But first, a word from our sponsor.
I met Tanner, who works for ConsultWebs, on a plane on the way back from Key West, Florida. And I'd just been thinking that I needed to do some more marketing for my law firm. So when he told me that he worked for ConsultWebs, I was super excited. From the beginning till even now, I've been with them for almost 2 years, and the experience has really been great. Having ConsultWebs on board is really like having your own team of people that really care about what kind of business you're getting. I mean, practicing law can seem kind of lonely. You always are wondering, how am I going to get clients? How am I going to make payroll? But with ConsultWebs, it's not just me worrying about having people come in the door. They're there as well. And they've been so responsive. Since I started with ConsultWebs, I have increased the number of employees double at least. And since I started with ConsultWebs, the revenue has tripled. So it's really been an incredible experience.
Go to consultwebs.com to learn more.
And now, a Lawsome interview.
Wayne Pollock was a litigator at Deckert LLP, one of the largest and most prominent law firms in the world, with more than 900 attorneys worldwide and more than $1 billion in annual revenue. In his more than 6 years at the firm, he obtained favorable outcomes for clients by analyzing and presenting complex legal factual issues. After leaving Deckard in 2016 and based on his decades of experience engineering positive public relation results for clients, Wayne founded CopoStrategies, where he helps his clients manage media relations ethically, strategically, and proactively during legal disputes to this very day. And as if this wasn't enough, he's decided to enter the Lawsome Court of Opinion. Wayne, thanks for being here.
Thanks for having me, and thank you for that clearly ad-libbed introduction.
We're really masters at improvisation. Talk about PR. We've known some law firms that do it well. It seems like that's in the minority. How does CopoStrategies help, and what makes you guys different from a more traditional PR communication shop?
Yeah, so we are a legal services and communications firm, and that's a key difference. It's not just marketing speak. As an attorney, we work with other attorneys and their clients to, as you said, ethically, strategically, and proactively engage the court of public opinion to help their clients resolve their cases favorably. And oh, by the way, help those attorneys build their practices in the process. Plaintiffs' attorneys and their clients come to us to help them shine a spotlight on cases and get some public attention for them. And defense attorneys and their clients call us when they want to help extinguish the fire and turn around the negative publicity. What's different about what we do is we focus on a mix of legal strategy, media strategy, ethics compliance, and defamation avoidance. Unfortunately, many times when attorneys go to outside PR firms, these PR firms could do a very good job of dealing with the media, but they don't understand legal strategy. And that's a huge deal when you're trying to get publicity and trying to get public attention for your clients' cases in a way to help your clients resolve their cases favorably. Ethics compliance is a big deal. Most attorneys have no idea that the ethical rules actually are fairly liberal in how attorneys can talk about their pending cases. And defamation avoidance, you would not believe the press releases that I see put out on press release distribution wires where attorneys defame the other side because they don't understand where the litigation privilege ends and where defamation starts. So we look like we're doing public relations because we're talking to the media, we're talking to the public about active pending cases, but really what we're doing is a very narrow type of legal advocacy. We're focused on the court of public opinion, and we're focused on advocating for our clients outside of court.
Oh, I was just thinking, does professional liability insurance cover defamation for lawyers?
That's a great question for your local malpractice insurance.
Bam! Shoot it back to the crowd.
Just try it, see what happens.
Well, it's interesting to say that this is like a serious issue. And I'm wondering if there are other people that see supportive structures. It wouldn't seem like that. I mean, so you advocate for clients in the court of public opinion. So what is that? It seems different. It seems scary. I mean, if you're on social media, it's a really vitriolic, divisive place. How do you make sure everything stays advantageous and control the narrative? Is that part of that media strategy?
Well, you're absolutely right. And one issue that attorneys tend to have and struggle with is in a court of law, we've got rules of procedure, rules of evidence. We don't have that in the court of public opinion. When you go and talk to the media about your clients' cases and they come back to you with questions or they go ahead and write articles about your clients, they don't have a record like you would have to cite in an appellate court. They don't have rules that they have to abide by in terms of what they can say or not say. Aside from defamation, you have a free-for-all in the media and in the public. And you're right, when it comes to social media, nowadays, it's not unheard of for things to bubble up on social media and then become a story in the mainstream press. You probably saw this sometime this week or last week, where you'll see an article like social media erupts at XYZ, and now what started on social media has jumped to the mainstream press. When it comes to legal disputes. And when it comes to attorneys and their outside people trying to frame legal disputes, all you can do is try to translate these legal claims, these factual claims that attorneys are making, into non-legalese that is easily digestible by the public. Because if the public can't understand what your claim is about, what your client's claim is about, they can't support it. And that's, I see as a huge struggle. Most PR people don't know litigation, they don't know the legal process or the substance of the law, so they have difficulty translating. And attorneys obviously know the law, but they have difficulty translating elements of a claim and kind of big picture ideas into words and concepts that are easily relatable to the client, and it's relatable by people in the audience. And look, in today's day and age, no matter what you say or do, if you're in a high profile matter, you as the attorney and your client are likely to be vulnerable to attacks from various sides of the spectrum regarding the work you're doing in the public eye. I think the important thing is when you have a legal dispute that raises these kinds of issues and gets the public talking about them, you have to stay the course. You have to continue with your messaging, with your framing of the dispute. You can't add fuel to the fire. You know, there's the idea in tennis of unforced errors, and that's an issue here where people say the stupidest things, especially attorneys, when they have a microphone in front of them. And it's important to not add fuel to the fire. It's important to not keep the negative conversation going. Nowadays, the news cycle and the attention of social media users and their Russian bot accomplices moves fast. There's just not much time that people will linger on something except when there are new things to talk about on that subject. So you get in, you get out, you say what you have to say, and you have to develop a thick skin. And that's part of what I think an attorney needs to do with a client is when you have a client involved in a high profile case, the attorney better warn the client that this is going to get heavy, hot and heavy. This is going to be the kind of case where you're going to get emails, people talking smack. You're going to have negative things said about you on social media and online. And you have to either be willing to deal with it or think again about actually pursuing your legal claim if you're concerned that this kind of public scrutiny is going to negatively affect the client.
Yeah. Well, it's tough too, especially for people who don't get into that stuff a lot. Like I guess I'm just thinking, we have one of our clients here in Chicago. They are, I would hold them up as a shining example of PR done right. But even in their articles that are in the paper where they're talking about a case or something like that, there's always somebody who's throwing in a comment, ambulance chaser, and they just, they're ready for it. They handle that. They understand all that stuff is coming there. They can, when they have a press conference with their client, you can tell everything is very managed and no one's surprised. So it's amazing. But I would say that's, they're the exception, unfortunately. But something we talked about earlier before we got on the air a little bit was ethics. And again, going back to this firm I'm talking of as an example of it done right. The other side of it I see is, a firm has to release a statement. And what happens is they don't really know. So they ship it off to their legal department to review it, to make sure it's ethical. And by the time that thing comes out, all the life has been whittled away from it. It isn't necessarily a narrative as much as it is a statement of what's happening. It doesn't seem effective, but I get where they're coming from because they're very afraid, and rightly so. Some states have some pretty strict rules with regards to ethics. So have you ever had any issues with tactics you use, or have you seen anybody run into this? And what do you do to make sure you don't cross those lines?
So I haven't had any issues, knock on an enormous piece of wood, but that's because we keep ethics very close to us, and we bake ethics compliance into everything that we do. The ethical rules are such that, generally speaking, obviously, I don't know where each listener is listening to this episode, but generally speaking, the ABA model rule, Rule 3.6, trial publicity, is that attorneys can't make statements outside of court that they know would have a substantial likelihood of materially prejudicing an adjudicative proceeding. And the U.S. Supreme Court has said that the reason for that rule is because we don't want to impact a jury trial. We don't want what is said outside of court to affect a judge's ability to assemble a jury panel and a jury's ability to actually decide a case based on what's admitted into evidence in that case. But there are a number of safe harbors. And to that rule, one safe harbor has 10 categories of information that attorneys can always discuss no matter where they're at in a case. And the other is a rebuttal safe harbor where if you are not the one starting the publicity, you can rebut negative publicity to the extent necessary to help kind of undo the harm. That safe harbor, the first safe harbor, with the categories of information, attorneys can always talk about the contents of a public record. Attorneys can always talk about their claims, offenses, and defenses in a case. The issue that attorneys run into when it comes to ethics is when attorneys start getting into inadmissible evidence. When you, as an attorney, start talking about evidence that you should reasonably know will not be admitted into court, that's when there is a problem. And that's when the rule really starts to stiffen up. So what I see the biggest issue with attorneys and ethics is there are some cases where attorneys like to talk and use rhetoric in a way that goes above and beyond the claims and defenses in their case, goes above and beyond the contents of a public record, and starts to really make the jury think about things outside of any possible evidence. So, for example, I remember a case recently where a gag order was put into place by a judge, where the plaintiff's attorneys were calling this doctor, who I believe engaged in medical malpractice, they were calling him like the butcher of something, wherever the town was. And the judge was like, no, we're not going to have that. And the plaintiff's attorneys, they're shot themselves in the foot because their language there, their conduct led to a gag order. And ironically, most gag orders are simply reinstating the ethical requirements of Rule 3.6. So that's a little tip for any listener. If you're ever in a high-profile case and there is a gag order being discussed, before you push back and say no gag order whatsoever, look at the language. You might be surprised that the gag order might only be a regurgitation of Rule 3.6, of the ethical rules that you're supposed to be abiding by anyway. The gag order might apply to your client, which is, obviously beyond what the rules of professional conduct would normally do. But think about that next time you have a gag order. So anyway, I see that kind of language as the biggest issue. Once in a while, I'll see case law come down where an attorney distributed expert reports publicly before trial, which could be an issue because there's no guarantees expert reports are coming in as evidence. But generally speaking, the inadmissible evidence issue is the biggest thing that I see with attorneys and ethics. I do see once in a while attorneys just getting into such rhetoric that creates a circus atmosphere in the court and amongst the participants, and a judge just puts his or her foot down and says, look, we can't deal with this kind of conduct. You're going to prevent me from being able to run this court and run this trial the way that I want to. A similar issue is defamation, and defamation always surprises me how many attorneys don't understand that even though you could say whatever the hell you want in a legal complaint, assuming you sign it, and it's made in good faith, magically, when you talk to reporters or you mention those same allegations outside of court, if you're not sprinkling the magic pixie dust words like "as we allege," "as our complaint states," "as we contend," if you don't use that kind of buffer language and you simply repeat your allegations or your conclusory legal claims, you're running into defamation issues. And I'll blow your collective minds. In many states across the country, attorneys can be liable as a matter of law when they send a copy of an as-filed complaint to a reporter. And the idea is that an attorney runs afoul of the litigation privilege when he or she does this, because the same kind of concerns and the same kinds of protections that the litigation privilege give attorneys when they're making their possibly defamatory claims inside of courts don't apply when you take those same statements outside of court. And the mere publishing, the mere sending of a complaint, even if it's the publicly available court stamped version to a reporter, as a matter of law, gives rise to a claim of defamation. There are usually good factual defenses that you as an attorney could make, but your adversary who's suing you for defamation is going to get past the motion to dismiss stage, because as a matter of law, in many states, in Pennsylvania, it's at the Supreme Court. The Pennsylvania Supreme Court has binding case law that says sending a complaint to a reporter is, as a matter of law, gives rise to defamation. So there's ethics, but defamation is kind of lurking there in the shadows. And if you're not careful, you really can step into it and pose a problem, because now you have like a parallel litigation concerning one case, and that parallel litigation is regarding your defamatory statements about that first case. So it's a nightmare for attorneys and their clients, and it requires someone to understand exactly what you can say in a way that's persuasive and credible, but not unethical and not defamatory.
We talked a little bit about this before we hit record. The cautiousness around language, especially with lawyers in the legal community, prevents them from being as persuasive as they could be in a marketing capacity, in an advertising capacity. And it's something that's baked in, as you say, to their thought process. So does that sort of make this PR marketing brain more difficult for lawyers, especially to access? And it's better to have an expert and a firm help you. Is there something there about the marketing PR kind of vibe there?
Yeah, I think that there are always going to be potholes to look out for when you've got an industry that's as regulated as a legal industry.
Right.
And that's why you have firms that specialize in this kind of work. Like an attorney, if they're going to refer a client to, let's say, a criminal defense attorney, would the referring attorney want to go send their client to a general practitioner who does 15 different things and, oh, by the way, once a year is in criminal court? Or do you send the client to someone who all they do is practice criminal defense work? It's the same thing. It's why ConsultWebs has built their business up to the amazing status that you guys have now, because when you focus on law firms, you have this understanding of all the possible things that even attorneys themselves aren't thinking about when they are going to market themselves and when they're going to go to the media and the public regarding their active cases. I think that it helps to have someone or some firm to be able to give you the lowdown on all of the possible issues, just like the way attorneys issue spot for their clients. I think it's incumbent upon firms like ConsultWebs, firms like my firm, CopoStrategies, to help guide attorneys and say, look, we could do this, but you should know that we have some concerns about how this language is being used or what you're trying to say here. The advertising rules as they apply to digital marketing are almost hilarious, where, you have some old standard advertising rules about the size of fonts on envelopes, but digital marketing doesn't use envelopes. So what do you do? There's issues everywhere. And the flip side of that is, just because things are difficult doesn't mean that you should avoid them. Look at the number of firms, rightly or wrongly, in terms of how well they execute. Look at the number of firms that spend tens and hundreds and millions of dollars a year advertising, both in traditional formats as well as on our digital formats. They've obviously cleared the hurdles. They've obviously done their due diligence and figured out the path forward. And any attorney who files a document in court theoretically could be liable for sanctions. In terms of the document saying something wrong or saying something untruthful, there's always risk. And I think the job of a firm like ConsultWebs, the job of a firm like mine, is to help attorneys understand, look, when we go to the media about this particular case or this legal dispute, here are the things that I would suggest that we stay away from. Here are the things that we could say. Same thing, I assume on your end, when attorneys want to create new programs and new campaigns, you guys are advising both on what is the standard practice in terms of ethics, but also copywriting. And enough is enough about the bio that just lists all of your awards. No one cares about that. All they care about is how you could help them. So I think you have to know the industry. And as I alluded to before we started recording, there are a lot of PR firms out there that claim to do litigation communications, which is the PR equivalent of the court of public opinion work that I do.
Right.
But when you go to those websites and you talk to those people, they're used to doing one thing only, that's talking to the media about legal cases. They don't understand the full range of issues, legal strategy, ethics compliance, defamation avoidance. And I think attorneys have to understand that when they go to an outside vendor, they can actually rely on that outside vendor's expertise, lower E expertise, lowercase e, to help them do what they have to do to succeed on the marketing and PR front.
Love it, man. A disclaimer within a disclaimer.
Yeah, that was rad. Especially, we noticed it. I was just sitting there thinking about it when you were talking about that. We noticed it particularly with like mass torts and stuff. Like you got to be really careful when it comes to claims, medicinal, pharmaceutical stuff like that. Like they're real particular. So we've talked a lot here about like what you can't do, some of the pitfalls, some of the stuff like that. But I'm just kind of curious, just like a quick sketch. What do you think like a successful PR for a law firm looks like? Like, do you have a system? Do you come in with a template? Is there like bullet points? And then to kind of add on to that, do you sit down and like I was talking before, how there's always going to be the trolls or the naysayers or the haters. Do you put in a crisis plan for that kind of stuff? Like when you sit down with a firm, you have an idea of what it's going to look like. Like, how do you get from where they are to where they should be?
Yeah, it's, there are PR firms that would love to sell law firms $50,000, $75,000 crisis planning packages where they do a simulation and they go and then they write a crisis plan, and all this work looks beautiful. It's a nicely produced document. And then, your managing partner of the law firm is accused of being an accomplice to like Jeffrey Epstein, or your, managing partner is caught up in the Operation Varsity Blues scandal earlier this year that caught up the former chairman of Wilkie Farr, the big law firm. And all of a sudden your crisis plan is just not worth the paper it's printed on, because the crises that you anticipated actually didn't happen. Something even crazier happened. Well, I'll answer your last question first. My definition of a crisis plan is simply making sure attorneys understand who are the people that have to be assembled quickly in order to have a conversation about a response. You could go down the list of things like, how do we send a statement to the press if one of our partners is accused of sexual harassment? What do we say if one of our associates or partners dies suddenly? Like, there's some value there. But in this day and age, there are things that pop up, crises that pop up that you just can't predict. And I think the more important and the more effective use of people's time is to say, okay, if we were to have some kind of crisis, we were going to get a phone call from our local daily newspaper about some alleged wrongdoing. Who are the people that have to almost literally be around the table or be on the phone to decide, okay, we're going to have our chairman, we're going to have our CMO, we're going to have our outside marketing person, or if you're at a smaller firm, we're going to have our head paralegal, we're going to have our litigation partner. You have to get a feel for the culture of the firm in terms of crises. Taking a step back, when it comes to just general public relations planning, I think that marketing and PR are intertwined, and it's important to understand what marketing could do for PR and what PR could do for marketing. There's many definitions for marketing and many definitions for PR. I don't want to get into the official clinical descriptions of each of those, but I think it's important to figure out, like, from a law firm's perspective. A lot of law firms focus on prospective clients, and they focus on digital marketing for prospective clients. And they infrequently think about referrals sources. What can I do to get my referral sources to pay more attention to me? How can I get them to always be thinking about me and my firm when they have a case that's right up my alley that they might go to another firm for? Many law firms don't think about the media. And in some practices, the media just isn't going to be a huge part of the marketing and PR spectrum. So, for example, if you're a family law practice or a wills and trusts practice, it's rare that the kind of cases that you work on are going to make the news or be newsworthy. But there's a newsjacking component where if a well-known celebrity or a well-known local figure dies and they don't leave a will, well, if you're a will and trust attorney or a state's attorney, you should be going to the media, your local media, and say, hey, I know so-and-so just died and you've reported that he or she doesn't have a will. I'm an attorney that focuses on wills and trusts and estates. And here are some things I think your readers might like to know about why it's so important to have this will or have a will or an estate plan. So there's public relations things that firms can do even when they are unlikely to get a sniff of a high-profile legal dispute. They are things they could do more locally with referral sources, with the media. I like to advise my clients that they should be viewing what they do in terms of marketing and PR as a newsroom type operation. What are the things that are going on within the firm that can be, quote, reported out to the people that we think are important to the firm's success? Newsletter content, social media fodder, blog post fodder, developments on your website in terms of case developments. Even if you don't have the kind of practice that people are going to cover, like a true PI slip and fall practice, can you create a news operation where every week or every time you have a favorable development in a case, you post that information, you comply with the ethical rules, you make sure you have the client's permission. If you don't, then you just provide some kind of anonymous, non-descriptive detail about the case. But what can you do to tell your story and tell your firm's story? Because if you're not telling your firm's story, then no one else is going to do it for you. You have to get that ball rolling. And I think that's where PR dovetails with marketing. Marketing, at least from my perspective, and now with digital marketing, is very much focused on prospective clients and making sure that the firm is positioned in front of those prospective clients. But that ignores a lot of other opportunities and a lot of other ways that client matters come into the door. And it's important for attorneys to understand what PR and marketing can do together and separately on those fronts.
PR is like the gold nugget from marketing. If I could market your practice, I could get you in the news. And PR is like, we're in the news. Like, what are you talking about? It's so fascinating that all of this sort of seems like a waste of time to a lot of law firms who are like, yeah, but I need those prospective clients.
Sure.
And it's interesting to think of this other perception of your marketing activities. Everyone thinks it's just SEO busy work. I mean, you hear law firms being like, nah, I'm not going to be a newsroom. I'm not going to be a content, wheelhouse. Like, that's just not my thing because it's a waste of time. And it's interesting because they're telling their story through their service, but they're not telling a story about their service. So no one knows that you served anybody. It's so basic, but it seems so revolutionary. I mean, are you still kind of dealing with this paradox here?
Well, I'll tell you what, let me give you an example of the way public relations serves a marketing function. And it happens frequently where after my clients get publicity for a case they filed or a favorable development, they get a phone call from a prospective client. And I'll give you a perfect example. So one of my clients filed a lawsuit regarding a negligence lawsuit against a funeral home in New Jersey. Within 48, and we got some good press for the filing. Within 48 hours, they got a phone call from a client in Florida with a similar issue with a different New Jersey funeral home. What's the connection? That client's son passed away. He was living in New Jersey, and they were from New Jersey, but they relocated to Florida, and they still every day read the New Jersey newspapers online. So you have a client here that didn't have to click a link. You didn't have to chat with. You didn't have to go through the normal acquisition costs. They called the law firm and said, we saw an article about the lawsuit you filed against XYZ funeral home. We had the exact same issue. Can you help us?
Wow.
It amazingly pre-screens and pre-sorts your prospects, because when people see you doing this work for a particular kind of client and a particular kind of case, they come to you, and the third-party endorsement that the media provides is unique, and it really resonates with legal consumers. And if they see you as an attorney advocating publicly for a client, they're going to say to themselves, these prospective clients, well, holy crap, I hope he or she can do that for me. Like, look at how they're going to bat for the clients. We as attorneys, we get inundated with digital marketing requests,
sales pitches. I'm sorry about that.
No, none from the consultwebs-emails.com. But you've got the press, which in many instances is limited based on the media industry contracting, but nonetheless, you still have this amazing channel for attorneys to use about their cases. And the amazing thing is, when you start talking publicly about your clients' cases and your firm's cases, you never know who is on the other end of that newspaper article, or that online media article. I've had clients who have received, as I said, new clients based on media coverage. I've had clients who have had people come out of the woodwork and say, I'm not involved in this case. I don't have any claims, but I know someone who worked at that company, and they could probably provide you some information that may be helpful to you. This is like an unofficial whistleblower who isn't coming forward with a case, but saw news about his or her former employer or the friend's former employer, and wants to provide information to the attorney that could be helpful in discovery and could be helpful during the trial, that they would have never known about. But they got a public spotlight on the dispute, a public spotlight on the issue, and magically people read it and people consumed it, and people saw that they had information that they could share. I mean, there are a number of similar marketing benefits when it comes to going to the media. I think one of the hidden benefits is client service. You have many clients who want their stories to be told. They literally hired an attorney to tell their story in courts. And many clients, not all, but many clients want to tell their story publicly so that other people don't suffer the way that they've suffered regarding a faulty seatbelt, or a nursing home that didn't take care of their elderly parent, or what have you. And many attorneys don't understand that when you pursue that angle, when you, with the client's perspective and client's permission, go to the media, that client says, holy crap, Jake went above and beyond for me. I'm going to refer him to my friends and family. I'm going to definitely leave a testimonial and a favorable review, because he advocated for me well beyond what I thought an attorney was willing to do. And now all those usual marketing things we talk about, reviews, testimonials, it's all supported and enhanced by this public relations function.
So we got to wrap this up because people have things to do, Wayne, but you are unreal, man. You've really helped explain a lot of this in a way that really makes it tangible. I wrote, and I'm drooling. I was just drooling while you were talking. It is so brilliant. People want to learn more about you, Wayne. How can they do that? How can they find CopoStrategies online?
Yes. So if I appreciate those kind words and the drooling. That's always a nice outcome during one of these conversations.
Yeah, I cleaned it up. It's fine.
Yeah. Okay. Good. So you can visit my firm's website is CopoStrategies, COPO, which stands for the Court of Public Opinion. CopoStrategies.com. We have videos, free resources, articles, anything attorneys might like to learn about regarding ethically, strategically, and proactively engaging the Court of Public Opinion. And let me give you one piece of homework. You, the listener, let me give you one piece of homework. I would recommend that attorneys take a little bit more of an active role when they're reading any news articles about legal disputes. Read those news articles the same way you would read an adversary's court filing that you have to respond to. Look at the nature of the legal dispute, the posture of the legal dispute, what's being said, who is saying it, what's the source of information, is there a slant, are both parties chiming in? And I think if attorneys are able to be a little bit more of an active reader when they're consuming news about legal disputes, they will have a better appreciation for the kinds of cases sitting currently in their files on their desk or on their servers that could lead to similar news coverage with a little bit of finessing and a little bit of effort to take those cases to the media.
5 questions we ask everyone.
What was the last book you read?
I'm just about done Built to Sell, which is an allegories type book about how to structure a business in a way that makes it not only better running, but prepares it to be sold in terms of increasing its valuation and making it attractive. So it was a real interesting book. And it's like an allegory. So it's a story about someone, but it in the course of the story being told gives you pointers for what you could do.
Hell yeah.
That's so cool.
Number 2, what is your favorite place?
Yeah, it's got to be the beach, because when I'm on the beach, my 2 young sons can dig the same hole for 8 hours, and I can just veg out and enjoy the sun, the ambient sound of the ocean, and hopefully minimal emails.
Nice. That sounds awesome. Number 3, what sites, blogs, newsletters, or podcasts do you regularly check in with?
So I'll give you one recommendation for a podcast. It's called The Science of Success, and it is a podcast that focuses on the science of basically doing everything better. It's fascinating, and there's tips about kind of like life hacking, but they have the researchers and the scientists on who did the studies, and it's enlightening that you can actually do things better if you understand how. And what the research says about what makes that new way more effective.
Nice. Okay, number 4. If you were stranded on a desert island and could only pick one condiment to take with you, what would it be?
It's got to be spicy mustard, the kind of spicy mustard that right after you consume it, just goes up your nose.
Yeah.
Oh, man.
That horseradish kick. Hell yeah.
Yeah. None of that usual yellow.
All
offense to listeners out there.
No, none taken. That's okay, number 5. After a long day or a long week at work, how do you relax and unwind?
This is going to sound like ridiculous, but it's with the kids. When the kids run around on a weekend, I'm out of the office. I have a chance to just be with them. And look, if we could all, as lawyers, as entrepreneurs, bust our tails during the week and occasionally on the weekends. But if you're not spending your time with your family, then what's the point of going so hard all the time?
For show notes, links, and info, go to thelawsomepodcast.com or follow us on Twitter or Facebook. Be sure to leave us a review and rating in iTunes or wherever you find the you listen to. Until next week, stay lawsome.